Closing Arguments with Vinnie Politan. Tonight, starting at 6/5 Central on the all-new Court TV.
Welcome back to Court TV Live. We are in a verdict watch, day 4, hour 15 plus. This is California versus Kellen Winslow II. And let me tell you, a verdict can come in any second now, because it's not just day 4. It's not just past 15 hours. No. It is Friday, my friends. And you know what? Historically, statistically, juries come back with verdicts most often on a Friday because they don't want this lingering over the weekend. They don't want to have to come back on Monday. They don't want this weighing on them, spending the whole weekend worrying about this. So we are waiting with bated breath because we think that this verdict could come in any minute. So you're going to have to keep it right here. Let's go inside the courthouse to our Court TV crime and justice reporter, Julia Janae, who has been watching the comings and goings of the jury. Julia, what's the latest?
Seema, we are here in the hallway. We watched them come in, or come out of that room rather, and go back in. They've been back in now after the lunch hour for about 30 minutes now. It's 1:30 here on the West Coast, and that lunch break that they took, shorter than normal. They asked for a shorter one, which tells us that they are trying to move things along as much as possible. But otherwise, everything is quiet here on this hall. There's not a lot that's going on in these other courtrooms. And of course, the attorneys for both sides, they are not anywhere in sight because they will be waiting, like we are, for whatever comes out of that jury room. If there's a note, we will know about it, and we'll of course bring that to you. And if there is a verdict, we will bring that to you. But again, it is 1:30 here on the West Coast, and normally they have wrapped up things around 4:30 to 5 o'clock. So only 3 more hours before things should be getting extremely interesting here in Vista.
I can't believe things have been interesting all week for me. And this is, I can't believe it. It's Friday. I mean, you're a lawyer, you're a journalist. You know that Friday's usually the day, right, Julia?
This could beat the historic odds. I don't know, Seema, but I will tell you that if this does go against history and go against your statistics, then they will not be deliberating over the weekend. They would be coming back on Monday. So that would be what will happen if at the end of the day today they have not reached a verdict. But we are still waiting, and we'll of course bring you the very latest.
Good for them, good for us, and good for you because you can take care of that cold over the weekend. Thank you, Julia Janae. So, folks, we've been breaking down the testimony and the evidence surrounding all of the Jane Does just to bring it back to you because this deliberation's been going on for 4 days, and we want you to know why this is a nail-biter. Let me remind you, Kellen Winslow II is facing life in prison if he is convicted of all the charges. Now, let's talk about Jane Doe number 3. The evidence surrounding the accusations of Jane Doe number 3, she claims Kellen Winslow exposed himself while she was gardening in her front yard. Prosecutors called to the stand a computer forensic examiner to explain how the Strava cycling app, maybe some of you have it on your phones, that app confirms Winslow's movements on the day of the alleged incident. Can an app do all that? Let's watch some of the testimony and find out.
Now turning to Court's Exhibit 87 for identification. Is there another afternoon ride associated with the same Strava user account with the name Kellen Winslow Jr. and the photograph we just discussed?
Yes, sir.
And does that show that there was an afternoon ride on the day prior to May 24th?
Correct, it does.
What was the date that's associated with this printout?
It's Wednesday, May 23rd, 2018 at 4:15 p.m.
And does that show that there is a origin on the GPS coordinates that's contained here?
Yes.
And was that also in the city of Encinitas?
Yes.
And then was there a ride down the coast highway into Solana Beach down towards Del Mar?
Yes, correct.
Showing now Court's Exhibit 88. Does that show a close-up view of Lake Drive as it extends down to Birmingham Drive for this ride?
Yes, sir, it does.
And does it show the GPS track actually stops or continues and makes a loop into what would be the residence area of the homes that are near that corner of Lake Drive and Birmingham Drive?
Yes, sir.
Showing you now Court's Exhibit 89 for identification. Do you have that in front of you?
Yes.
Does that show the same user profile by the name of Kellen Winslow Jr. and the photo that we've identified?
Yes, sir.
And does that show an afternoon ride labeled for a particular date?
Yes, it does.
What's the date associated with this afternoon ride?
This one is Thursday, May 10th, 2018 at 2:45 p.m.
GPS coordinates that are associated with the ride on May 10th of 2018?
Yes.
And did that also originate in the Lake Drive area of Encinitas? Or the city of Encinitas?
Yes.
And did it extend down on El Camino Real to Manchester Road?
Correct. Yes.
Showing you Court's Exhibit 90 for identification, does this show that on May 10th, the route taken by, that was automatically recorded by the GPS data, does that show that it extends southbound on Manchester Road near the 5 freeway?
Yes, sir, it does.
And does it show that the route taken went along Manchester Road and near the San Elijo Lagoon in a loop to the west of the 5 freeway?
Yes, sir, it does.
And it then continues on and extends through the Cardiff area of Encinitas and southbound on Coast Highway, is that right?
Yes, sir.
Just one moment, Your Honor.
All right.
Thank you, nothing further, Your Honor.
All right, cross.
Just a couple questions. A Strava app user doesn't log into the app using a fingerprint, do they?
No, it's an email address and password.
There's no iris scan or anything like that.
Correct. No.
So it's possible that a person could use a registered user's Apple Watch or their Garmin, record a
Now, that was a very important witness to prove the charges with respect to Jane Doe number 3. Let's bring in criminal defense attorney DOD Ghassemkhani, who can help figure out why this random forensic examiner was allowed to come in and testify about the Strava app. Dodd, why wouldn't they call a representative from Strava? And I believe Strava's located in California. They could have just driven them down or something as convenient.
That's a great question, Seaman. That's the question that I've been wondering all along this entire trial. I believe what we heard at the trial was that the DA's office attempted to get a representative from Strava to come in and testify, and they were unable to. I believe that might have been heard in some of the pretrial hearings. But allowing a computer forensic expert to testify on the Strava app with no expertise at all in the Strava app, other than her being an avid biker, is extremely troubling. And Judge Bowman allowed it in as it goes to the weight of the evidence, not its admissibility. But at the end of the day, what does that really mean, weight versus admissibility? A jury doesn't know what that means. All a jury is going to look at is the actual map of the Strava, and it puts Mr. Winslow at or near the residence, and that's pretty damning evidence for the defense.
I love that you brought up weight versus admissibility, because I think it's an important point, and I think something our viewers are very interested in to know the legal machinations behind these rules. But again, right, the forensic examiner, excuse me, talking about GPS and those type of elements, completely fine. But an app that is much more complicated and was created by other people, is managed by a separate organization, it just doesn't make sense that she was allowed to bring it in. In fact, during the questioning in that soundbite, you heard that I think it was Prosecutor Owens asked her, "Oh, do you personally use the app?" What does that have to do with anything? If she personally uses the app, I've been using MyFitnessPal from December 2015. Is someone going to call me to testify about MyFitnessPal? Because if anybody knows how to use it, it's me. And okay, so here we're showing our viewers now the Strava, the map of the Strava route, which, you really can't tell much, because if you're looking at this map, you could think, oh, maybe he just drove by and he saw her in the garden. It was that easy, but not so fast, because if you look at the body cam really was very introspective into this home. You really get, it's almost like a maze the way this body cam follows this very lush, plush terrain that is, this garden that's behind the house, not very easy to get to. You really have to maneuver your way around all these plants and the little sidewalk, the front yard area, kind of going off, the body cam's following to the left of the home, and then again going a little bit farther into a path. So it's certainly not that easy. Now, if, let's just say, Winslow is convicted on these counts with respect to Jane Doe number 4, do you think the allowance of the Strava app evidence would be something the defense could appeal on?
Well, absolutely. I mean, when I look back on this case, I think there are several issues that could be brought up in appeal, and the number one issue I see is this Strava app. I mean, to allow this computer forensic expert who has no expertise in this app, who has no idea how the data is stored by Strava, to come in and testify that this is how the Strava app works and this is how the GPS, tracking system works. You could have brought in anyone to testify that's used the Strava app to come in and say, well, I use the Strava app, and 99% of the time when I use the Strava app, it's accurate and it shows exactly where I biked to that day and came back. So I think that is extremely prejudicial, and it is something that will be looked at by an appellate court in the event of a conviction.
That's right. And I believe at some point I misspoke. We are talking about Jane Doe number 3 here. There are 5 accusers in total. Just reminding the viewers, there are 5 accusers. This was Jane Doe number 3. And also, this is the Jane Doe number 3 who did not identify him in a photo lineup. She never even was asked to identify him in court. She described him as being several inches shorter. She admitted she never looked at his face. So this Strava app could really be the nail in the coffin for Kellen Winslow II with respect to these charges. DOD Ghassemkhani, thank you so much for your expertise. And our verdict watch rolls on. Folks, a verdict could come in any minute now. It's Friday, it's day 4, and we are almost at 15 and a half hours. We're in a verdict watch. It's day 4 and about 15 and a half hours, and a verdict could come in any second, so you do not want to go anywhere. Kellen Winslow II, there's no question that he was a gifted athlete. He made All-State in 2001 when he was just a high school senior, and then he went on to win the NCAA National Championship the same year as a true freshman playing for the University of Miami, which makes the charges against him and this perceived fall from grace so much harder to understand. Our CourtTV legal correspondent, Chanley Painter, explains.
From high school all the way to the NFL, Kellen Winslow II has commanded attention.
And all you had to do is look at his athletic resume to understand the talent.
He was somebody to watch.
Following in the footsteps of his Hall of Famer father, Kellen Winslow Sr., Winslow II carved an athletic legacy of his own. One Union Tribune sports columnist, Bryce Miller, followed for years.
One of the best players in football in San Diego history, and by default in California history. Even in high school, he was one of the best ever play in state history.
At Scripps Ranch High School in 2001, a teenage Winslow was already making headlines. He earned All-State in football, gaining the attention of college recruiters across the nation.
My dad and I
we couldn't come to an agreement on which school I should go to. I wanted to go to Washington. He wanted me to go to Michigan State. I was like, you know what? I'm just gonna go to Miami.
He was very angry at his father for blocking his way to Washington at that point. Later, he would go on to say it was a great decision. I'm glad he ended up at Miami. That was a moment where father and son had to sort through something that was a clear moment of conflict.
During his freshman year at the University of Miami in 2001, Winslow played as a starter for the Hurricanes. That year, his team would go all the way.
I guess if you win a national championship your first time out, and a couple years later win the Mackey Award, it's hard not to think it's a good decision.
Winslow decided to forego his senior year of college, allowing the Cleveland Browns to select him as the 6th overall pick in the 2004 NFL Draft.
That's the reason I wore 81, because I wanted to be one better than them. I wanted to be one better than my dad.
In 2004, Winslow signed the largest rookie contract for a tight end in the league's history. He would go on to play only 2 games before breaking his leg on the field. And the following year, a motorcycle accident threatened the same leg. Doctors feared amputation. But beating the odds, Winslow recovered and returned to the gridiron.
Well, Kellen's reputation, I mean, he's a great football player. He was a better athlete than his father. I mean, but there's a difference between being a better athlete and having a better career.
Veteran sports analyst and former NFL player Jamie Duke says Winslow helped evolve the tight end position.
A guy who was undersized for a prototypical tight end, being able to have a guy in line, lined up with the offensive lineman, and then running routes with that kind of speed, he probably was, and still may be, well, one of the best athletes to be that new generation of tight end.
Winslow played for 4 teams in his 10-year NFL career, including the Cleveland Browns, Tampa Bay Buccaneers, New England Patriots, and New York Jets. During that time, he caught 469 receptions, scored 25 touchdowns, and had over 5,000 receiving yards.
I know he caught a lot of balls. K2 was more of he moved around the several teams, and when you start moving around teams, that basically, pretty much eliminates any opportunity probably for you to reach the Hall and have that kind of career.
Winslow made the NFL Pro Bowl team in 2008, and when he left the NFL in 2014, his time in the spotlight faded until allegations of rape put a microscope on the sports star's behavior.
For Winslow to stand trial on 2 counts, forcible rape and rape of an unconscious person.
The son of Chargers star Kellen Winslow, Kellen Jr., is a member of he was a tight end in the NFL for 10 years himself.
You immediately knew that this was something that people were going to pay attention to.
Me personally, knowing his dad and what type of player he is, I don't think he did it.
Former Browns player C.J. Jones says the allegations do not match the man he knew as a teammate.
I don't think he raped him. He even got to do that. It's Kellen Winslow, man. I don't think he has to do that.
Now, behind the doors of a San Diego courthouse, the people depict the former player as a predator.
You will learn over the course of the next few weeks that Kellen Winslow took what he wanted. He took what he wanted, not from 1, not from 2, but 3 women. He victimized 5 women.
Kellen's defense calls the charges false and the high cost of his celebrity.
He's been in the spotlight since he was young. When you're in the spotlight, people want things from you. And that's just the way it is.
The final outcome rests in the hands of a jury of 12, tasked with deciding where Winslow's legacy goes from here.
Will this NFL star be set free, or will he go to prison for the rest of his life? It's in the hands of the jury, and we are expecting a verdict at any moment. The Verdict Watch continues after this. We are in a verdict watch. It's California versus Kellen Winslow II. Welcome to Court TV Live. In day 4 of deliberations in the Kellen Winslow rape trial, the jury has had the case now for over 15 and a half hours over the span of, yes, just like I said, 4 days. Now we have Court TV's legal correspondent Chanley Painter, who's been inside the courthouse throughout the duration, and we have crime and justice reporter Julia Janae, who has been, Julia Janae's inside the courthouse. Chanley Painter's outside the courthouse. Court TV has this covered from door to door. Let's start off with Chanley Painter. Chanley, it has certainly been a chaotic 24 plus hours between the readback of Jane Doe number 4, the readback of Jane Doe number 4's friend Nicole Edwards, and then we had yet another jury note today. So if you just don't mind bringing our viewers up to speed, take us back to that Jane Doe number 4 note. The jury requested her testimony as well as Nicole Edwards, and they've requested some text messages that they did not receive.
Right, that was the note yesterday, right before lunchtime here in Vista. The jury sent a note saying, we would like to have a readback of Jane Doe number 4's testimony and Nicole Edwards' testimony. They also asked about exhibit number 154. It wasn't in there with them, so they were wondering about that. Well, they spent the lunch break, the court reporter put all of that together, so it took about a couple of hours, and all the attorneys, the defendant, the jurors gathered into the courtroom yesterday afternoon, and the reporter read the transcript from Jane Doe number 4's testimony, got almost all the way through it, but the judge did address the exhibit. He said that they will not receive that exhibit. It was taken out of evidence as the defense objected. It was hearsay, and that was sustained, and so... But if you were listening to the testimony, they did refer to it in the readback, and the jury was noting down whenever they were talking about number 154. And then this morning, we continued with the readback of Jane Doe number 4, moved on to Nicole Edwards as well, and right at the break time between those two, the jury left for a break, Seema, and that's when the foreperson gave a note to the bailiff, and we had the next question from the jury, and that was what was addressed today. And it said, hey, it would help us if you could define what under oath actually means, and also, let's see the second one, how to follow the law and not what we think the law should be. So those are the two things they asked about this morning, and the judge did address those as well.
So with respect to the Jane Doe 4 readback, yesterday the readback took, I think, over 2 hours. And I want you to correct me if I'm wrong about that, but it seemed like that readback took over 2 hours. There were some breaks in there. And what I found quite compelling was the delivery by the court reporter. Even though, and as she's instructed, these court reporters, they're told you just have to say the words, you can't inflect, you can't show emotion, you can't be animated. But because the words she was saying was so powerful, I felt almost as glued to the court reporter's readback than I did to the original testimony. So I'm wondering, how did the jurors react when they heard that readback of Jane Doe number 4?
I was watching the jury quite closely, and it was pretty telling when they were taking notes and when they weren't taking notes. And it's kind of a good thing. She's easy to listen to. That's good, because it is a couple hours of readback of testimony. So what I noticed, Seema, was the jury, most of them, not all of them, most of them just furiously taking notes when she got to the part about the events leading up to the alleged incident and what happened back in 2003 between Jane Doe 4 and Kellen Winslow II. And then their note-taking sort of waned off a little bit after that. And even when cross-examination time came, there weren't many notes being taken except for a couple of noticeable jurors. Mostly number 2 and 12 were very much taking notes, especially when 4 was being cross-examined on the inconsistencies in her stories. And the foreperson seems pretty even-keeled throughout all of it. He's taking copious notes, as he's done every day during the trial.
And as we know, it only takes one juror to get some readback. So that could have been the case. Now, there was an interesting moment during the readback of Jane Doe number 4's testimony and Kellen Winslow's reaction. So let's play that for our viewers.
Question: what happened after Kellen left the room? Answer: Matt started to help me get dressed. Question: after Matt started to help you get dressed, did Kellen come back into the room at all? Answer: he looked, I don't know if he came in fully, but I know he came in back and he says, "She's just a stupid bitch," and then closes the door.
We actually have a closer look at that same clip, a closer look at Kellen Winslow. Let's check this out.
After Matt started to help you get dressed, did Kellen come back into the room at all? Answer: he looked, I don't know if he came in fully, but I know he came in back and he says, "She's just a stupid bitch," and then closes the door.
So that was really subtle, Chanley, as you saw, Kellen Winslow just did this like tiny little flick as to say, no, it looked like to me at least, as he was saying, no, that's not true. I didn't say stupid bitch. But when Jane Doe number 4 testified and said those words, his head, as you remember, was completely down, focused on his note taking, and there was no reaction at all. Did you find Mr. Winslow to be more reactive or less reactive or something in the middle during the readback?
Definitely. He's been more open with his reactions throughout the entire readback. Even how he enters the courtroom, he seems quite a bit different than when the trial was actually taking place. And that was just one instance of many times where he shakes his head in disagreement. And it's more noticeable when the jury was out on a break and the judge was talking to the attorneys on how to answer the note this morning. He was almost participating, it seemed like, with what he thought the answer should be with his attorneys, and that is very telling. He sits there and he's watching the jury react to the readback. He's paying a lot of attention. Usually we see him just taking notes or looking down at his table and passing papers to his attorneys, but not during the readback. It's a very different Kellen Winslow II.
I wonder if it's because the witnesses, including the Jane Does, including the civilian witnesses, law enforcement witnesses, just all of them, he found to be more intimidating. Like maybe he was just told to behave a certain way and keep his head down and take notes. And then during the readback, in a way, he feels more free to be himself. I don't know. But Chanley Painter, thank you so much for your reporting, my friend. Let's bring in CourtTV's crime and justice reporter, Julia Janae, who is inside the courthouse, who has been glued to the comings and goings of this jury. Julia, any movement since they've gotten back from lunch? Have your eyes been fixed on that deliberation room?
They have been peeled, Seema, but absolutely no movement from this jury, no notes, no buzzing to the bailiffs to come in. Everything has been completely quiet here on a Friday afternoon in this courtroom and on this third floor where they are behind that door deliberating. So now it's been about an hour and a half that they have been deliberating since their lunch break. They are inside, we know, diligently going through all of this information.
Now, the last note that we received, it was several hours ago now. Actually, before I ask you a question about it, let's play some sound from Judge Bowman on the last note, which I think is a third note from the jury.
I just received the note before he went out from the foreperson. It was handed to the bailiff. The bailiff just handed it to me. The note reads as follows. There's two sections to the note. The first part says, the jurors could benefit from an explanation as to what being under oath means. So I will explain a little bit further what being under oath means. You have all heard every witness who comes into the courtroom take an oath to tell the truth. And that is an oath where they have to agree to tell the truth, the whole truth, and nothing but the truth. And that oath requires them to, when they take the stand, not only here at trial, but also at the preliminary hearing that was held some time ago, that requires that witness to testify truthfully. If they do not testify truthfully under oath, they are subject to the penalties of perjury of the state of California. Now, I hope that answers the question, but When somebody takes an oath to tell the truth, they have to tell the truth, the whole truth, and nothing but the truth. And you heard over 30 witnesses.
So, Julia, that note came in at approximately 2 p.m. Eastern time, which is 11 a.m. Pacific time. So now it's about 3 hours, a little more later. What has the jury been up to in the last 3 hours?
Well, I'll tell you, the timing of that note was particularly interesting because it didn't come out of the room that we've been watching. It came at a time that they were in the courtroom for already a certain amount of time, probably about 30 minutes. They had taken a break, and when they came back from their break, so not from deliberations, but they came back from their break, is when that note was passed to the bailiff and then provided to the judge. It actually came rather before they went on their break. So this was passed to the judge at a time that they had not been in deliberations. So it just is an interesting timing that that note came out. It tells us maybe that the foreman wrote this note perhaps during the readback, or if he wrote it while they were in deliberations, he held it and didn't pass it to the judge until after they had gotten through about half of today's readback. But in answer to your question, since they have given that note over to the judge and then received the instructions or reiteration of the instructions from the judge, they then finished out the readback of the testimony of Nicole Edwards, and they then were released back to deliberations. After that, they went to lunch for an hour, and they've returned here and again been in deliberations for a little over an hour now.
Okay, Julia Janae, I know you will come back to us the minute you hear anything. Thank you so much. And listen, folks, we're on a verdict watch, but the minute either Julia Janae or Chanley Painter or any of our Court TV team in San Diego hears anything, we are going to bring that to you immediately, and we're going to bring it to you live. We're in a verdict watch, day 4. Any second now, the jury could come back with a verdict. That's right, it's day 4, approaching 16 hours of jury deliberations. We're on a verdict watch. Now, we've been looking back at the case against Kellen Winslow II. Right now, we're going to take a closer look at the investigation into Jane Doe No. 1's case. Some consider Jane Doe No. 1's testimony to be the weakest of the other accusers. However, Winslow's DNA was detected on her pants, so there is evidence of some type of incident, but Jane Doe No. 1 was unable to identify her alleged assailant, and there was also some conflicting testimony about what caused the blood stain on her white pants. Detective Mike Benavidez investigated her case and testified about how difficult it was to get in touch with Jane Doe No. 1. Let's go back and watch some of that riveting testimony.
All right, next witness.
Thank you, Your Honor. The people recall Detective Mike Benavidez.
All right. You're still under oath, so you can come on up. All right, and as I indicated, you're still under oath from this morning. All right, so direct examination.
Thank you very much, Your Honor. Detective Benavidez, have you been present during the testimony of Jane Doe No. 1?
Yes.
Now, I'm going to ask you, in addition to some of the things we talked about this morning during your testimony regarding the collection of evidence, I'm going to ask you about some dates and time that relate to your investigation into the reported sexual assault of Jane Doe No. 1. Now, was the first contact, based upon your knowledge, the first contact that she had with law enforcement after this incident, March 21st of 2018?
Yes.
Did the deputy who took that report, was that Deputy Stevens?
Yes.
Did you in fact review the recorded interview on a body-worn camera video recorder of the contact between Deputy Stevens and Jane Doe 1?
Yes.
When, as you said this morning, you were assigned the case for follow-up within a couple of days. I think you said March 25th of 2018. Was that one of the first things you did?
Yes.
Why was it that you reviewed the initial point of contact interview from the sheriff's deputy with Jane Doe 1?
Just to clarify the statement she provided to Deputy Stevens.
And in terms of you as the sexual assault detective, when you're following up on a crime report, is it fair to say that at least in terms of your experience, that the initial contact for a crime report may be more limited questioning than a follow-up interview?
Yes.
What did you do after reviewing the first recording of Deputy Stevens' interview with Jane Doe 1?
I telephoned Jane Doe number 1, requested to meet with her in person for a formal interview.
Why did you do that?
Just so I can clarify her statement and see if she had any additional information to provide.
And do you recall the date that you first attempted to make contact with Jane Doe 1?
I had to refer to my notes, the exact date.
If that would refresh your recollection
Yes.
as to the efforts you made to contact her and interview her, please do.
March 30th is when I telephoned her.
So if you were assigned the case on March 25th, you reviewed the interview, you attempted to contact her on March 30th, is that right?
Yes.
Now, once you had attempted to contact her, were you successful in actually reaching her initially?
No.
What did you do?
I left her a voicemail, gave her my contact information to call me.
Did you receive a return call?
No.
What did you do after that?
I actually telephoned the area detective at the station to obtain more information about the case.
And after doing that, did you ultimately attempt to contact Jane Doe number 1 again?
Yes.
When did you do that?
I did that on April 18th.
Now, we're talking about over a month after the incident and nearly a month after she first reported it. Did you ever receive any additional contact or any intervening contact from Jane Doe 1 in response to your first voicemail?
No.
Is it fair to say that she wasn't banging down your door trying to find you?
That's correct.
Now, based upon the lack of contact with Jane Doe number 1, was there a decision made to suspend your investigation at a certain point?
Yes.
Now, you were present during the questioning of Jane Doe 1 as related to whether or not she elected to participate in a sexual assault examination. Do you recall that testimony by her?
Yes.
Can you explain to the jury how it is that you explained to a reported victim of sexual assault her options in terms of whether or not she would like to complete a sexual assault exam?
Well, every victim that I have of a sexual assault, we do offer a SART exam with the forensic nurse, and I explain the process as far as the questioning. There's examination done by the forensic nurse, and when we do bring him or her to the SART facility, that forensic nurse again explains in detail the process.
And do you explain to them at the outset that it is their right to either participate in one or to decline one?
Yes.
Did you ever personally have that conversation with Jane Doe 1 as it related to this case?
As far as offering a SART?
Did you? Yes.
I didn't offer a SART because when I watched the body-worn camera, Deputy Stevens had offered the SART.
That was my next question. Was there, in fact, a time on March 21st when Deputy Stevens, based on your review of the recording, had actually done that already?
Yes, he did.
And did he ask her if she would like to go to the hospital to complete a sexual assault exam?
Yes, he did.
Did she decline?
She declined.
Did he tell her that it was her right to either accept it or to decline it?
Yes.
Okay, we just hit the 16-hour mark. It is day 4. We're on a verdict watch. A verdict could come in any second now in California versus Kellen Winslow II. We are on a verdict watch. A verdict could come down any second now in California versus Kellen Winslow II. The jury has had the case for 16 plus hours. This is day 4. And it's Friday. And you know what? Historically, statistically, juries come back most often on Fridays. And let me just remind you, Kellen Winslow II is facing 5 accusers. charges that span from 2003 until 2019. Now we're taking a look at all the accusers. Specifically, right now, let's take a closer look at the investigation into Jane Doe number 1's case. Detective Mike Benavidez investigated the alleged rape of Jane Doe number 1. He testified about the photo lineup that he showed her. Now let's go back and watch some more of his testimony.
Now, when, based upon your experience when you're conducting a sexual assault investigation, do you oftentimes see individuals who decline to participate in a SART exam?
Yes.
Have you personally been present during at least the initial portion of a sexual assault exam where the same is explaining to the reported victim that what her options are?
Yes.
And that what the actual process itself entails?
Yes.
Would you characterize it as an invasive physical process?
No, I would not an invasive. It's just a collection of evidence.
Now, at least as it relates to Jane Doe 1, you were never involved in a direct conversation with her about her reasons for not wanting to participate in the sexual assault exam, right?
No.
So then moving forward from the time that you attempted to contact her again in April of 2018, do you recall when it was that the case was formally suspended?
I'm referring to my notes here.
Please do, if it would refresh your recollection as to that date.
On April 26th.
Now, what was it that came to light that reopened that case investigation into the incident that Jane Doe 1 reported?
When there was another reported incident in Encinitas that Detective Johnson had received.
And I think that we discussed it briefly this morning during your testimony, but were you in fact contacted by Detective Johnson, who worked within your same sexual assault unit, about a separately reported stranger rape?
Yes.
You already described what a stranger rape is, but what was it about the separately reported incident that had common characteristics with yours?
The suspect description and the vehicle description.
Do you recall what about the suspect description in your case was similar to the other case?
A light-skinned black male.
Was there a description of tattoos extending from the arm all the way up to the shoulder?
Yes.
Was there a description of the vehicle?
Yes.
What were the common attributes regarding the description of the vehicle?
A black-colored sports utility vehicle, SUV.
Now, you heard the testimony of Jane Doe 1 and you reviewed the video recording with Deputy Stevens. Did she in fact initially describe the vehicle as a Hummer or like a Jeep?
A Jeep.
And when you spoke to her ultimately on June 12th of 2018, was that in fact the second time that you had personally met with her?
Yes.
Do you recall the specific date that Detective Johnson reached out to you regarding his sexual assault investigation?
I do not.
When was the first time that you met with Jane Doe 1?
When I showed her a photographic lineup and obtained her DNA oral reference swab.
Did that take place on May 17th of 2018?
Yes.
Now, sometime between when Detective Johnson's investigation was initiated and May 17th of 2018 is that about the time frame when you would have had conversations with him about the common features between the two?
Yes.
On May 17th, how did you reach out to Jane Doe 1 and ultimately meet with her?
I called her and requested that she meet with me, and she agreed.
So she answered the phone this time?
Yes.
What do you recall explaining to her what the reason was as to why you wanted to meet with her now?
Well, I told her that we had a similar incident that may or may not be related to her case, and I requested that she use a photographic lineup.
And did you in fact go to meet with her to show her a photographic lineup?
Yes.
How is it that you develop a photographic lineup in order to show to a potential witness?
We have a potential suspect identified, and that person is placed in a set of photographs, of 6 photographs with 5 similar facial characteristics.
At that point in the investigation, did you have a potential suspect identified?
Yes.
Who was it?
Kellen Winslow, Jr.
How was it that, and is that the same person you've identified in court?
Yes.
How was it that you had, at least at that point, identified Mr. Winslow as a person of interest, at least within the sheriff's department?
Just based on Detective Johnson's report, or the incident is very similar to my case.
And obviously we're somewhat out of order chronologically, but was there in fact a positive identification of Kellen Winslow on May 14th of 2018 in that sexual assault investigation?
Referring to Detective Johnson's case?
Yes.
Yes.
So then on May 17th of 2018, as you're meeting with Jane Doe 1, did you attempt to show her a photographic lineup that included a picture of Mr. Winslow?
Yes.
If I may just have one moment to switch over to...
Okay.
Thank you, Your Honor.
Let's break down the investigation into Jane Doe number 1 with criminal defense attorney DOD Ghassemkhani, who is still with us live from the San Diego courthouse. DOD, this was a convoluted situation, needless to say, with Jane Doe number 1. First, she didn't report for 4 days, which is fine. She decides that she doesn't want to do the SART exam when she does report, and then at some point, this detective can't find her. But you and I have been through this, okay? As lawyers, this happens with clients, with witnesses. Oftentimes, people, regular folks, aren't married to their cell phones like lawyers, like us, right? So sometimes we do have trouble keeping in contact. But the question is, does that necessarily mean the crime didn't occur just because your witness may not be the most reliable?
Well, absolutely not. I mean, as you said, I mean, we've tried these cases, and there's really no perfect way for any victim to act. But what I think is the most telling with Jane Doe 1 is the whole defense theory of, this is a money grab, this is a money grab. Well, if this was really a money grab, you would think that Jane Doe 1 would not only report right away, she would follow up with the detectives. When she was contacted by the detectives, she would follow up with them right away. So the defense's theory that this is all a money grab and everyone's going after Mr. Winslow's money in this case is very inconsistent with the fact that they had to suspend the investigation until Jane Doe 2 came forward.
Exactly. They had to suspend until Jane Doe 2 came forward. But okay, so do you think that this is the normal practice of law enforcement to perhaps look at another crime and then go back and say, wait a minute, this fits the pattern of a previous complaint that we received a few months ago, a few years ago, maybe?
Well, absolutely. I mean, their case is only as strong as their victim. And if the victim is going to call and make a report of sexual assault, and then they're going to follow up with her and she's not going to call them back, there's only so much that the detectives can do at this point. And I believe, they did the right thing. They suspended the investigation. They tried to contact her for, I believe it was almost a month, and she wouldn't contact them. So there's really not much more that the detectives could have done at that point.
And you just said the case is as strongest as their latest victim, which brings me to the jury instruction with respect to Jane Doe number 2 and Jane Doe number 1. You remember there's that instruction that says if the jury finds beyond a reasonable doubt the accusations supporting Jane Doe number 2, then they can use that as a factor in considering the charges against Jane Doe or charges with respect to the accusations involving Jane Doe number 1. So you can take what you find from Jane Doe number 2 and use it for Jane Doe number 1. And also, DA Owens, he opened his closing argument talking not about Jane Doe number 1, not about the first who testified, but Jane Doe number 2. So is this in a way a backdoor avenue to get a guilty conviction for the charges with Jane Doe number 1 and avoid all this inconsistencies that she created?
Well, absolutely. I mean, the way the case was brought from the beginning, is to get a guilty conviction on all Jane Does. I mean, they consolidated all the cases, and by consolidating the cases, it already puts Mr. Winslow at a significant disadvantage by having the jury hear all 5 Jane Does in one trial. Now, with respect to that jury instruction that you're talking about, I believe it's Cal Crim 354 as it relates to the propensity of Mr. Winslow. And the argument Mr. Winslow made is if you believe he's a sexual deviant and you believe he committed this act beyond a reasonable doubt, you can consider that in whether or not he committed the crime on Jane Doe number 1.
Yes, absolutely. And I think that's certainly what's occurring here. But it does seem that the jury is following the law, because if, listen, this guilt by association, having so many accusers, if the jury was going to say, okay, this just looks bad, guilty on 1, guilty on all, but just because we're here, it's day 4, it's 16 plus hours. It is Friday evening, rapidly approaching on the east, certainly approaching on the west, and they're still hard at work, which leads us all to believe they are following the law and they are looking at each of these cases separately. Dodd, thank you so much for your expertise. Now I want to bring in Chanley Painter, our Court TV legal correspondent.